Hello, and welcome to session one of our three-part series on hiring, avoiding legal pitfalls. These are designed to give you easily digestible learning you can consume on your lunch break. So let's get started. Today's bite-sized session may have a lot of things you already know, but hopefully a few things you didn't. What you need on an employment application and what shouldn't be there, interviews and pre-employment inquiries, and avoiding GINA issues and pre-employment physicals. So, even if you're comfortable with the regulations and best practices, there are requirements and subtleties that even experts sometimes miss. The job employment application is the official form that employers ask all applicants for a position to fill out. The job application is filled out offline in pen and paper format or increasingly online. The job application provides a consistent format with the same questions that must be answered by each person who applies for an open position. The job application is a legally defensible listing of your job applicant's employment history, educational background, degrees, qualifications, references, and more. And unlike the resume or cover letter that are written and formatted to highlight the applicant's most significant and impressive credentials, the job application is a listing of questions that require factual responses. Dates of employment, positions held, and contact information for supervisors, dates of degrees, names, address, and phone number are examples of facts required on a job application. An employment application should not include any questions that will produce a response that would indicate an applicant's protected class, such as age, race, national origin, disability, etc. Although many states and federal equal opportunity laws do not directly prohibit employers from asking such questions on an application, these types of inquiries may be used as evidence of an employer's intent to discriminate unless the questions asked can be justified by some business purpose of the employer. While the law does allow for bona fide occupational qualifications, BFOQ, which permit discriminatory practices in employment if a person's religion, sex, or national origin is a BFOQ reasonably necessary for the normal operation of that particular business. Establishing a BFOQ generally does not apply to most employers. To establish the defense of a bona fide occupational qualification, the employer has the burden of proving that a particular class of employees would be unable to perform the job safely or efficiently, and that the bona fide occupational qualification is reasonably necessary to the operation of the business. Typically, it's difficult for most employers that are not a religious organization to invoke the BFOQ defense, as the parameters surrounding it are limited. Information needed to conduct background checks should be obtained on a separate form authorizing the employer to conduct the check. Some of the most common inquiries to avoid are birth dates. Making inquiries about an applicant's birth date can give the perception that the employer is using age as a decision-making factor in the hiring process. If federal law or the employer's state law requires a minimum wage for employment for certain occupations, then the employer can ask applicants if they're at least the minimum age requirement for employment. Graduation dates. Making inquiries on an applicant's school graduation date can reveal an applicant's age. To obtain information on whether an applicant holds a degree or diploma, the employer can simply ask if the applicant has graduated and what degree was obtained. Educational requirements. Certain educational requirements are obviously necessary for some jobs. However, if the educational requirement exceeds what's needed to successfully perform the job, and if it disproportionately excludes certain racial groups, it may violate Title VII. Military discharge information. Questions that are relevant to work experience and training received are permissible. However, an employer should not ask an applicant the reason he or she was discharged from the military or request to see military discharge papers, except when directly related to the job or to determine a veteran's preference. Military discharge questions could result in obtaining medical disability information on an applicant, which is protected by the Americans with Disabilities Act. They can also lead to disparate impact based on race or a violation of state military discharge and anti-discrimination laws. To obtain information about an applicant's military service, an employer is permitted to make inquiries on the dates of the military service, duties performed, rank during service at the time of discharge, pay during service, and at the time of discharge, the training received, and work experience. Previous sick days used in employment. In general, the employer should avoid asking any questions about the amount of sick leave taken in an applicant's past positions. Both the FMLA and the ADA prohibit discrimination and retaliation against applicants who have exercised their rights under those acts. Race inquiries. An applicant's race, color, or national origin should not be asked on an employment application. Some employers may track their applicants' race for affirmative action plans or compliance with the Uniform Guidelines on Employee Selection Procedures, UGESP. But this should be done apart from an application. Employers normally use a separate form or a tear off section removed from the application. This information is not used in the selection process and is voluntary for the applicant. Citizenship. Inquiries about an individual's citizenship or country of birth are prohibited and can be perceived as discrimination on the basis of the individual's national origin. Applicants cannot be discriminated against based on their citizenship status, except in rare circumstances when required by a federal contract. An employer can inquire if an applicant is legally eligible to work in the United States and inform the applicant that proof of his or her eligibility to work in the United States must be provided if selected for hire. Maiden name, Miss, Mrs., or Miss. Many states prohibit marital status discrimination, making any questions related to that status possible evidence of discriminatory hiring practices. Social Security number. Although asking applicants for their Social Security number is not unlawful, requesting this information from applicants is not recommended due to identity theft and privacy concerns. Employers do not need this information until it's time to run a background check or complete a W-4. Therefore, including it on an application carries unnecessary risk. In addition, some states require security measures to be in place if applications asking for Social Security numbers are transmitted electronically or mailed without being in a sealed envelope. Salary history. Some states prohibit an employer from requesting salary history information from candidates. These laws are designed to promote greater pay equality by forcing employers to develop salary offers based on job requirements and pay on market pay levels. Criminal history, often referred to as ban the box laws. Many state and local laws require employers to remove criminal history questions from the employment applications to protect applicants and candidates convicted of a crime from automatic disqualification during the selection process. There are several steps employers can take to ensure that application forms are not discriminatory. First, employers should avoid asking questions that may elicit information about a job applicant's age, race, national origin, religion, gender, or other protected characteristics. Next, information sought on the job application should focus on the essential functions of the position being filled, not on the individual characteristics of the person applying. For example, an appropriate question for a job requiring employees to work during some evenings would be, "Are you available to work at night if necessary?" A potentially inappropriate question would be, "Do you have reliable childcare when work in the evenings is necessary?" Finally, employers should make job applications readily available to all applicants, whether in hard copy form, electronically, or both, so that all potential candidates can apply for the position. So now let's talk about interviews and screening. The selection process generally starts with the screen, moves on then to the in-person or nowadays maybe a video interview, then moves on to the assessment and evaluation of all candidates, and then step 4, which is the select and offer. So let's start first talking about the screen. Selection screening involves analyzing the candidate's application forms, resumes, and curricula vitae to locate the most qualified candidates for an open job. This is usually less than 20 minutes. It's usually conducted by HR, and it's useful for a high volume of applicants because it identifies applicants who fit a minimum selection criteria, provides information for reference checks, provides a source of questions for subsequent interviews, and helps to ensure that managers or other internal stakeholders spend time interviewing only qualified candidates. The next step in the process is the interview. Usually, this is 1 hour or more. It's usually conducted by line management, and it may include interviews conducted by potential colleagues. Selection interviews are designed to probe areas of interest to the interviewer in order to determine how well the candidate meets the needs of the organization. You're asking the candidate a series of questions, and you're qualifying candidates more than any other procedure in the selection process during this interview. And it requires that interviewers are properly trained. There are different types of interviews, from a structured, where every candidate is asked the same questions and it's a repetitive interview, You have the unstructured, where it's more conversational and it builds on a candidate's responses. And it's also called a non directive interview. Behavioral is probably the most common, and it's focused on how a candidate handled past situations on pointed questions about minimum qualifications. Give me an example when, or describe a situation where, or tell me how you handled. Then there are competency based interviews where you're asking candidates to illustrate how they demonstrated the needed knowledge, skills, and abilities in the past. So, how did you manage this situation? What did you do when X happened? Group interviews are where multiple candidates are interviewed at the same time, and each candidate is interviewed by multiple people, also referred to as fishbowl interviews, team interviews, or panel interviews. And then stress interviews, where the interviewer puts the applicant under some degree of stress, like the interviewer attitude or puzzles or case interviews or simulations. Effective questioning techniques are where you can actually turn each desired skill set or job characteristic into a series of open ended questions. Facilitate the candidate's sharing of their experience and expertise through their responses. So, asking these questions can lead a candidate to describe in detail their technical expertise or discuss core competencies, or actually demonstrate problem solving behavior, learning, and communication style, as well as other necessary attributes. Recruiters and hiring managers must be cautious to avoid inquiries based on an applicant's protected class or risk a claim of discrimination. The EEOC looks at with extreme disfavor on questions about age, color, national origin, race, religion, gender, or veteran status. If employers are asking these questions, they would have a difficult time proving the questions were not used in the hiring decision. In addition, as stated previously, many state employment laws expressly forbid certain types of questions. Title II of the Genetic Information Non-Discrimination Act of 2008, GINA, which prohibits genetic information discrimination in employment, took effect on November 21, 2009. Under Title II of GINA, it's illegal to discriminate against employees or applicants because of genetic information. Title II of GINA prohibits the use of genetic information in making employment decisions, restricts employers and other entities covered by Title II, such as employment agencies, labor organizations, and joint labor management training and apprenticeship programs, referred to as covered entities, from requesting, requiring, or purchasing genetic information, and strictly limits the disclosure of genetic information. In order to comply with GINA, an employer should be very careful when interviewing and hiring potential employees and make sure that questions asked do not violate the law. For example, an employer should avoid asking questions about an applicant's medical history or information about their family medical history. An employer should always remain focused on whether the applicant has the ability to perform the essential requirements of the position. An employer should also make sure that its job applications are compliant and avoid asking for genetic information. It may place a small paragraph regarding the compliance with GINA at the end of the job application, or include a brochure on the GINA policy in the application materials. It is critical for an employer to make sure that its employment forms comply with GINA and it does not unlawfully request information about genetic history and family medical history of employees and applicants. Relevant employee forms may include releases authorizing the release of medical records for pre employment physicals, fitness for duty examinations, or return to work physicals, health risk assessment forms for wellness programs, and leave request forms. Where applicable, employers should include a disclaimer that the employee is not required to fill that portion of the form out and that any release of any genetic information is inadvertent. Further, an employer should ensure that any forms that it uses to obtain medical information or that might result in the acquisition of genetic information contain the EEOC's safe harbor language designed to minimize the likelihood that genetic information will be disclosed in the completion of those forms. Certainly, if you have any questions or you just want more information about anything that was shared in today's mini session, you can reach us at support@hr-shield.com or give us a call at 844-4HR-PROS. You can also visit our website at www.hr-shield.com. And stay tuned for mini session number 2, where we'll be talking about more topics related to hiring and avoiding legal pitfalls.